You've been listening to the Secrets of Attorney Marketing podcast from Speakeasy Marketing. Call 888-225-8594 or email rj@speakeasymarketinginc.com to enhance your reputation and outmarket your competitor. Make sure you subscribe to the podcast and post a review.
Hello, this is Richard Jacobs with the Secrets of Attorney Marketing podcast. Today, my guest is attorney John May. He's the author of a book called Who Says You Can't? Strategy and Tactics for Criminal Defense Lawyers in the 21st Century. So I saw this book on a publication for NACDL, National Association of Criminal Defense Lawyers, and it looked really interesting. So I approached John and I asked him if he'd come on the podcast. So he's here today, and thanks for coming, John. How you doing?
Great. The title of the book now, they changed the title. It's Who Says You Can't? Strategy and Tactics for Becoming a More Creative Criminal Defense Lawyer. But the text of the book is the same. They just thought that the title would be better. It emphasizes really the theme of the book, which is fostering creativity.
And yeah, tell me a bit about your, how you started in practice and what your practice has been like and what led you to create this book.
Well, I started as an assistant public defender in 1979. I went to the University of Florida, Levin School of Law, and I was an assistant public defender. I did appellate practice, and then I was moved into the Capital Appeals Division within a year. I had my first argument before the Florida Supreme Court when I was 24, and I looked about 14. So I grew a beard so that I would look older.
You use that Brenton formula to gray your hair out too?
That time it wasn't great, but my wife was very unhappy in West Palm Beach where I worked, and I looked for a job in Miami, and coincidentally, the chief of the appellate section, the U.S. Attorney's Office for the Southern District of Florida, had gone on maternity leave, and her assistant had left, and consequently, they needed somebody right away. And I was not the typical person, generally hired at the U.S. Attorney's Office. I didn't have Harvard credentials. I didn't graduate at the top of my class, but I did have substantial appellate experience, and I'd been very successful. So I got the job, and I was with the U.S. Attorney's Office for 4 years.
Oh, very cool. What was that experience like versus being just a, run-of-the-mill prosecutor in a given state? What was it like to work for the attorney's office? What did you do that was different?
Well, we handled much more significant cases. Our office was, at that time, prosecuting the Medellin cartel. One of the appellate cases I handled involved the corruption by the insurance commissioner of the state of Florida. I did wiretaps for the public corruption section. It's a difference between the minor leagues and, the major leagues. Not to say that the work we were doing was more important than the work that a state prosecutor does, because state prosecutors handle murders, very serious kinds, say street level crime. And in that regard, it is just as significant. But certainly the kinds of work we were doing then had a different kind of sophistication to it. So it was very exciting. Had I not had a daughter, and my wife and I wanted Carol to be able to stay home with our kids, so I really had to leave the U.S. Attorney's Office for financial reasons. So my wife and I started our own law firm, and we had our law firm until she decided she wanted to retire, and I got a job with what we call Big Law, Joni Walker, which is an Am Law 200 law firm. And I stayed there for 6 years. I left and reopened my own practice.
So you've done the practice of law at many different levels and for many different entities, for private practice, government, etc.
Yeah, state government, federal government, private practice, small law, big law. So I've done a little bit of it all. And I've been fortunate to handle some cases of national significance. So, I've been lucky in my career.
How do you feel like you're different from, other run-of-the-mill, and again, I'm not looking down on them, they're very important people, but other criminal defense lawyers, because you have all these different perspectives, how is your defense different than theirs might be, let's say?
Well, what I tried in the last 44 years of my practice, I have tried to address issues that had come up in the practice of law that were controversial and where no one really had a good idea how to handle. And so, throughout my career, I would confront those issues, write about those issues, because I didn't like the idea that representation of an individual should be left to chance. I always thought that there should be a best practices that lawyers can follow in order, to have hopefully the best outcome and not have the representation of an individual be left to chance. So there are thousands of lawyers who have had, I would say, a more successful career in terms of representing their clients, but I have focused, a lot of my efforts in trying to solve problems that they encounter to give them the best advice on how to address those problems.
Yes, how did the idea for this book come about? We of course we want people to read it. What kind of juicy details can we give people out of it to get them interested in reading it? How will it help?
First of all, I think anybody could read the book. I don't have to be a lawyer. I discuss creativity through the lens of criminal law because it's the area I'm most familiar with, the one I can talk about and show how you can take different approaches to problems. But the techniques that I recommend, apply to any kind of problem solving. Now, certainly there are some chapters that would be more difficult for a layman to understand, and even for some civil lawyers to understand. But for the most part, you can get through this book and hopefully gain some real insights in how to look at problems differently and see solutions that you might otherwise see. See, for me, creativity is not about thinking outside of the box. Creativity, for me, is taking a hammer and smashing the box. And so, for me, you have to do that to really understand the nature of the problem and other ways of approaching it. So, I hope anybody will find it interesting, an interesting read. The first chapter is about the Boston Massacre trial, which I call it Defending the Impossible Case. And I title it Defending the Impossible Case because here was a situation where the 7 soldiers who fired on a crowd, Boston Commons, their actions were witnessed by hundreds of people. So you couldn't deny or what the facts were. The facts were just well known and impossible to defend in terms of saying things didn't happen. So in terms of an impossible case, you had eyewitnesses to the defendant's conduct. You also had legal principles in place under British law, which greatly favored the Crown in prosecuting the soldiers. And you had a hostile pool of jurors because the people of Boston hated the Redcoats. They were occupiers. So in many respects, the kind of case that John Adams was thrust into defending, I believe, was an impossible case, and yet he pulled off victory. And I go through details of the case to show the kinds of arguments that he made, which appealed to the jurors and convinced them that the right thing to do was to acquit 5 of the soldiers of murder and hold 2 accountable for manslaughter. And it was just a terrific victory. It's also interesting because one of the things that I point out is that somebody from 2023, if they went back in time, they would see a trial that would look very familiar because many of the things that go into management of a trial today were invented back then. You had voir dire and peremptory challenges by the lawyers. The lawyers hired private investigators to go into the city and collect statements.
Did they wear white wigs, or was that never in the U.S.?
Now, only the judges wore white wigs. You had jury sequestration. The jurors were all kept at the local jail so that they would be sequestered. You had a visual exhibit that was prepared for the trial. It wasn't used, but it was prepared for the trial. And you had, for the first time in history, a jury instructed that they had to acquit the defendants if they had a reasonable doubt. So what I say about John Adams is that he was the first modern trial lawyer in the first modern trial. And I think that makes the story interesting in terms of how he went about problem solving, which I suggest was both very creative and still relevant for trial lawyers today in terms of things that we can learn from what he did.
How much of success in a trial is just doing the right thing and, going by the book and, again, doing all the basics correctly, and how much requires creativity and going outside of the box and the basics to win?
I'm not certain that there's an answer to the question that you posed. Being successful from the standpoint of a criminal defense attorney, being successful depends upon your efforts to be more prepared than the prosecutor, both in terms of the kind of investigation and having better handle on the law, particularly the rules of evidence. So it's not really a question of, everybody has to adhere to the rules, but creativity comes from using the rules in a novel kind of fashion or obtaining information that people might otherwise not be able to obtain and use during the course of a trial. If I can give you one quick example.
Sure.
One of the things that I have proposed in journal articles as well as in this book is a radical transformation in how lawyers look at their cases from the time that they are retained to the time that their client faces sentencing if they plead guilty or are convicted at trial. Typically, lawyers do not really think about sentencing until after the defendant has pled guilty or after the defendant has been convicted. And that's when most of the work, the hard work, is done of preparing for a sentence. In some respects, if they're negotiating a plea deal and they are limiting the kinds of charges that are being brought, they're doing so with an eye towards what the client will face at sentencing. But what is not typically done, and what I have proposed that lawyers do, is to think about sentencing from the very first moment they meet the client. And the reason is, in federal court, 98% of all defendants plead guilty. Of the 2% that don't plead guilty, 70% of those get convicted at trial. So there is a 98 close to a 99% chance that the person who walks into your office and retains you to represent them in a federal criminal case is at some point going to be facing a judge, and a judge for purposes of sentencing. So to the extent that we put so much of our efforts into preparing for trial, we are really diverting a lot of resources in the wrong way. And yet most lawyers really are only thinking about, how they would convince a prosecutor to give them a good deal or win its sentence. Yet the irony is that all of the things that you need to do to prepare for a trial, you really need to do from the very beginning in order to prepare for sentencing. Now, let me give you one very concrete example. You cannot use hearsay at trial. I think most people know what hearsay is. It's just, something that somebody says out of court that somebody else testifies to in court. So if a witness in court says, well, I heard from my friend Audrey that she saw the defendant shoot Mr. Wilson, that statement can't come in. If the witness saw the defendant shoot Mr. Wilson, the witness has personal knowledge and can say that I saw the defendant shoot Mr. Wilson. But you can't come into court and say, Audrey told me. You got to have Audrey in court if she's going to say that she saw the defendant shoot Mr. Wilson. Now, that is a fundamental rule of evidence that essentially precludes hearsay from being admitted into trial. But the hearsay rules don't apply to sentencing. And consequently, lawyers might pass up the opportunity to get a statement from Audrey believing that it can't be admitted to trial, not thinking in terms of how it could be used at sentencing. I'm asking for a paradigm shift in how lawyers approach their cases, recognizing the reality that there's not likely to be a jury trial, and it's not likely there's going to be acquittal, but it is likely that the client is going to face sentencing and going to trial. And so we have to do things very differently if we are going to serve our clients' interests. So,
quick question here. So is this a statement about someone's character that might impact sentencing? Is that why you're bringing it up? Or what would be the use of a hearsay statement like that at sentencing?
Well, part of my argument in terms of the chapter, just give you a little small piece in terms of, how the evidentiary rules work. Part of my argument is, or the central theme of my argument is that we should be trying our case during sentencing. And that is using the tools of an advocate to put the defendant's conduct in a context that is more understandable for the judge, or that eliminates certain aggravating factors that the court might otherwise rely upon if we didn't have the evidence that we need to refute those facts. For instance, it's often the case that at the beginning of a case or prior to indictment, if you have an individual who knows that they are under suspicion and there may well be charges arising, there are people who are available to you who might have important information which aren't going to be available to you at sentencing, because once prosecutors and agents learn about their existence, these people often become unavailable and no longer willing to provide testimony. And so if you can get to the people early enough and get statements from them, because hearsay is not excluded at sentencing, this very exculpatory evidence you might be able to use before the judge in his determination of the appropriate sentence. Sometimes people, commit a crime, but they're not as responsible for the crime as a prosecutor may portray them to be. And so if you are going to get the court to provide a sentence, lower than what the prosecutor is asking for, you have to do everything that you can to make the defendant's conduct more understandable their conduct, showing that their conduct, that other people were doing worse things. There are just so many different ways of approaching it, but you have to have the right evidence available, and you have to think about in terms of it being used at sentencing as opposed to constantly thinking of it in terms of trial.
Okay. Any, from your memory, any cases that you've been on where you had to come up with something creative in order to get, a positive result? Anything comes to mind that, you fondly remember?
Well, I can tell you a case that I was involved in Tampa where our client had been caught with 200 kilograms of cocaine in the trunk of his car. And the car had been stopped as the result of a routine traffic stop by the Florida Highway Patrol. And the case originally went before a trial judge, and it came out that prior to when the defendant was stopped, there had been a drug deal involving the FBI. And it was a case where the FBI had let the defendant leave with all the drugs, which the FBI is not supposed to do. And the government just portrayed this as a coincidence that the FBI, that the Florida Highway Patrol saw a traffic violation. But the judge in the state court really thought that this whole situation was set up, and without anyone establishing any kind of connection between the FBI and the Florida Highway Patrol, he just dismissed the case, and then the case was brought into federal court. And I have frequently said to clients, I don't know how we're going to win this case, but it's my sense that if we put enough pressure on the government, a case can go away in a lot of novel, different kinds of situations. I don't quite recall the details, but we were able to establish that the Highway Patrol was actually taking orders from the FBI and looking for an excuse to stop the car, and that the FBI agents in federal court, we showed, had lied. Now, this was at a suppression hearing, and the judge, we didn't know if the judge was going to dismiss the case or suppress the evidence, but we were able to make such a stink about the relationship between the Florida Highway Patrol and the FBI and suggest that this may be a widespread hack, that before there could be any ruling by the judge, the U.S. Attorney, Donna Bucella, who had been a colleague of mine at the U.S. Attorney's Office, and she was now the U.S. Attorney in Tampa, she decided to just very publicly dismiss the case. And this was a case not winning at court, not winning a trial, but just bringing out circumstances that were just so suspicious. And it wasn't by proving that the FBI had called the Highway Patrol to stop the car, but creating such circumstances in terms of the examination of the agents, the FBI agents, that the federal judge would have had to make a ruling that the FBI agents perjured themselves. No federal judge wants to do that, and no U.S. Attorney's Office wants to handle that kind of thing. And the government just, dismissed the case to sort of sweep it under the rug. They didn't want any kind of widespread investigation of the relationship in Florida between the FBI and the Florida Highway Patrol.
That's Florida. Yeah. What has creativity ever come off? I mean, can it come off the wrong way to a judge as someone's trying to be too slick, and therefore the judge just closes their mind off to anything that you would offer them, even if it's super creative? Like, can this be done in the wrong way?
Well, offhand, I can't tell you that, because finding a creative solution to a problem is finding a way to discredit the government's case, or a different approach to the law, which forces the court to either say that the law doesn't apply in these circumstances or is unconstitutional, that kind of thing. We're not talking about any kind of sleight of hand or slickness or being, doing something. Yeah, we're talking about doing something that is done in a concrete way that has a concrete result that at first blush you thought couldn't be done. So certainly lawyers, things that lawyers try to do in court backfire. Like asking a question on cross-examination that you don't know the answer to, and having the witness say something that was devastating. I'll give you an example, of a really good example. When I was trying the Noriega case, when I was involved in trying the Noriega case, before I became one of the lead counsel, one of the two lead counsel, Frank Rubino was lead trial counsel, and I was lead appellate counsel. When I came onto the case, I was like completely unknown, the sixth person down at the bottom of the totem pole. But there was a problem, and the problem was that after General Noriega was brought to the United States, everybody abandoned him. His banker at the BCCI just flew the coop, and all of a sudden General Noriega didn't have any access to money. I mean, he just, in the past, the Panamanian treasury was his piggy bank, and he had no longer had access to it. So over a number of months, we were promised, the money would be here in a week or 2 weeks, and it just didn't happen. Well, we had hid this from the prosecution team because they were moving forward, preparing their case, but, we were frozen solid, and we needed resources to do stuff to defend the general. So I was given the job of convincing Judge Hoovler to try to do something. One of the other problems is that General Noriega did have assets, but had been frozen around the world so that he couldn't get access to his money, because the government argued that all of this money was the proceeds of illegal activity. And 9 months before, the U.S. Supreme Court had ruled that a defendant did not have the right to access to his money for purposes of the defense if it was frozen. So what I did was I filed a motion for an evidentiary hearing on the government's evidence to show that all of his money was tainted. And the next day after I filed that motion, Pat Sullivan, who was the lead prosecutor and another former colleague of mine at the U.S. Attorney's Office, called me and said the government was going to unfreeze his assets. Now, I nearly fell off the floor because I thought we were going to be in for a big battle and one we were likely to lose. But what I didn't know was that at that time, the government was having difficulty putting its case together and needed more time, and was concerned that if there would be such a hearing, all this troublesome stuff would come out. Sort of like what happened, years later in terms of the Tappan case I was talking to you about. So part of being creative is finding ways of putting pressure on the government just to see what comes out of it. Because, in my career, there have been a number of times when just applying the right pressure causes results that should not happen, where the law is against you and the facts are against you, and nevertheless, things blow up for the government.
Okay. Well, very good. John, you mentioned offline that the new book you've written, all the proceeds are going to a charity, I believe. So can you tell listeners where can they get the book and where are the proceeds going and why?
The National Association of Criminal Defense Lawyers has a foundation, and it's called the Foundation for Criminal Justice. And it's a way for them to raise money for different kinds of projects that are intended to advance a more humane criminal justice system. And so when the NACDL said they were going to print my book and started talking about the rather puny royalties I would get from the sale of the book, I said I didn't want it, that I wanted any of the proceeds to be to go to the Foundation for Criminal Justice. So I'm not making any personal profit on the book, but whatever money is raised will go for a good cause.
Okay, very good. So to get your book, people can go to the NACDL website, and will there be a listing for a new book that's out?
Yeah, if you go to nacdl.org/who says, capital WHO, capital SAYS, and it says SAYS, you'll get linked to the book. And so actually, if you just go to the NACDL website, nacdl.org, and click on the NACDL store, they will give you a listing of books that you can order, as well as T-shirts and coffee mugs, all the other stuff organizations sell to raise money.
Well, very good. Well, John, thank you for, your work and your advice and, for this book. Again, I found it very interesting just looking at the title alone. So that's why I wanted to speak to you and help others listening get benefit as well.
I don't know if you know this, but last night I sent you a PDF copy of the book. So you can't send it off to other people, but you can take a look at it at yourself at your leisure if you're interested.
Thank you. I appreciate that. That's great.
Okay. Thank you very much.
Thank you for coming.
You've been listening to the Secrets of Attorney Marketing podcast from Speakeasy Marketing. Call 888-225-8594 or email rj@speakeasymarketinginc.com to enhance your reputation and outmarket your competitor. Make sure you subscribe to the podcast and post a review.